USF LP versus USF Finance.
Good morning, Your Honor. May it please the court, my name is Zach Savage, and I represent the appellants Into USF Inc. and Into USF LP. And I'd like to reserve 5 minutes for comment.
Yes, sir.
This is an appeal from a grant of a motion to dismiss, where the trial court dismissed claims for breach of fiduciary duty against 4 directors of a joint venture for-profit corporation based on conduct the directors took with respect to that corporation. And there's no dispute that when each of the 4 directors accepted his or her position as directors of the joint venture, they, just like any other director of a corporation, assume fiduciary duties to that corporation. The only question is whether the pleadings conclusively establish that each of the 4 separate directors was acting within the scope of his or her employment when undertaking the breach of conduct, and thus whether the claims are barred by sovereign immunity. And I want to emphasize this point because I think it got lost in the briefing a little bit, and it provides a nice contrast to the argument that we just heard, which was on, of course, the summary judgment posture. Again, we are at the pleading stage here, and under this court's recent decision from City of Tampa versus Frederick, sovereign immunity is an affirmative defense that is not properly asserted on a motion to dismiss unless the complaint conclusively establishes its applicability. There is nothing in the pleadings here that conclusively establishes that the directors were acting within the scope of their employment when they undertook the breaching conduct. If anything, the pleadings establish the opposite. And the trial court's ruling effectively acknowledged that the pleadings did not establish each of the 3 prongs of the scope of employment test.
I don't recall it.
So the trial
court considered all 3 factors and expressly stated that. The trial court also told you, or your counsel below, I'm not ruling simply because they were USF employees. And asked, I think, Ms. Sanders that question down below. It was a good question.
So
It's clear that you didn't make the decision simply because they're USF employees. You made the decision based on the conduct. Now, this is your second try, right? Your second amended complaint. Because the trial judge told you to get a little more specific because you talking about wearing different hats, right?
That's right. And so our position is that had the trial court considered all 3 prongs of the scope of employment test, there is no way that it could have come to the outcome that it did. And in particular, the kind of conduct that the directors were hired to carry out by USF, it is certainly not established by the pleadings that the kind of conduct they were hired to carry out by USF would have included service on the board of a joint venture like this.
Well, let me ask you, because each one of them had business backgrounds, degrees, business acumen, experience in business, worked for the business department of USF, correct?
That is certainly correct, Your Honor.
And you also allege that simultaneously they're employees of USF, also giving us their positions as well as designated directors, correct?
That's right.
Your pleadings are very, very specific as to their positions, their statements, and their conducts. But when you get to how they breached, it gets vague. You say they should have done this, they should have been more diligent, they should have offered more suggestions about how to improve the financial condition. When we have it in your pleadings, they said don't do pathways anymore, do direct admit. And your client rejected that advice. So it's clear that not only did you expect them to give you advice, you took their advice, but when you didn't like it, you rejected it. I mean, I've gotten that just from reading your complaint.
So I just want to push back on the notion that because of the kind of background that each of these directors held, that encompasses service on the board to the joint venture. Because this is not an ordinary kind of board on which you might expect, say, the provost of the university or a CFO to serve. This is a separate corporation.
Yeah, but based on your pleadings, you were making a lot of money. You increased the prestige of USF. And this is a joint venture. In a joint venture, they're both working for their mutual benefit, correct?
That was the intent of the joint
That's the
venture.
nature of joint ventures.
But
That's what
every-
you set them up for.
Yeah, but every allegation about they knew this, they knew that, they should have informed you is vague, because there's no objective facts in there of how they knew what USF really wanted to do. What I can read from your complaint is they relayed to you that the Board of Trustees is very concerned about your financial condition and even offered you a suggestion. And then there's a time where someone high up in your company meets with the VP April 15th and 14th of 2022 about your poor financial condition. So it seems if you read from that, you can only glean that these people were offering you their business expertise as the fiduciaries, but you rejected it.
We don't dispute that these people obviously did act with respect to the joint venture. In fact, that is part of the underlying the comment that underlies the fiduciary duty claims. The claim here is that they had conflicting loyalties. Each of these directors, by accepting a position as a director of the joint venture, accepted the fact that they owed fiduciary duties to that joint
Well,
venture.
who created the conflict according just to your complaint? I'm not looking at anything else. If it's alleged that you rejected their recommendation to go to direct admit, your client rejected, who created that conflict?
Well, the conflict was created by virtue of USF appointing these individuals to serve on the joint venture.
You could
And
have fired them, couldn't you?
could the joint venture have fired individual directors? I don't know that's right. The USF itself has the ability to remove
I
joint.
didn't see anything in your complaint that you didn't like these people up until the termination.
Well, that's right, but I think that gets away from what, I just want to focus what is in the complaint. And what is in the complaint are allegations about what each of those four directors was hired to do by USF. And there's nothing in the complaint that alleges that service on the joint venture was one of the responsibilities that they were hired to perform. And that is the analysis that has to be.
I mean, this is, I cannot imagine USF would ever advertise an opening position. Hey, this is really unique, joint venture corporations being set up in partnership. We need to hire 4 people specifically for this job. Right, and so it's kind of just a question of how wide, how narrow you draw that strike zone, right?
That's exactly right, Judge Lucas, and the way that USF draws that strike zone is so impossibly vague that it basically means
They're
that
getting up to the chin and down to the cleats.
that's basically right. I mean, so you can see this in the director's brief on page 25, where they describe the kind of conduct that the directors were hired to perform. And what they say is that they were hired to perform conduct that was protecting the financial and academic interests of USF. That is what they're saying makes this conduct fall within the scope of their responsibilities at USF. So in other words, what they're saying that basically anything that they do that protects the financial or academic interests of USF is the kind of conduct they were hired to perform and is thus barred by sovereign immunity. But that just can't be the right test, because it effectively means that the kind of conduct prong of the scope of employment test does no work. All you have to do, if that is the right test, is essentially draw as high of a level of generality between what you were hired to do and the breaching conduct.
I'll push back on that a little bit. I mean, suppose USF appoints a custodial worker, or they go out and they find I don't know,
Volleyball coach.
volleyball coach, fine arts major,
Sure, you're right, Judge Lucas. It will not.
This is a little facetious, but
But
there is some limitation, some ceiling, some stripes.
Right,
Baked into even the more generalized position that you're ascribing to your comment.
But this is the position that they are taking, which is that the strike zone is something that is intended to protect the financial and academic interests of USF. And sure, that might not cover a janitor, but it would probably cover anyone in the finance department at USF.
But if we look at their job description, VP of Business Finance, CFO, a couple of VPs of Business and Finance, Provost Executive, VP Academic Affairs, and then you've got a Senior VP of Global Affairs and International Research. That is their job description. And from your complaint, and I'm just telling you, we're staying very faithful to the four corners of your complaint. Your business is there to recruit international students, to teach them foreign languages, including English, to matriculate them into the school, obviously at a cost. Somebody can get a profit, but isn't that the goal? Correct. Okay, so these people, not only are they this, position at USF, they benefit your joint venture.
That's absolutely.
No question, correct?
Well, there is a question about that, Judge Kelly.
Well, I can't see from your complaint what they did wrong, other than terminate it and didn't tell you about it. Because you've got all kinds of allegations about the advice they gave, they invited you to meetings, they told you what was going on, they told you what the Board of Trustees, which could have been, a violation of confidentiality, I don't know, but they're telling you what the Board of Trustees, their really significant concerns about the financial condition of your company. But you said, no, we're going to rebound from COVID, we're not going to direct admit.
So just in terms of what they did wrong, look, the merits of the underlying fiduciary duty claim are not before this court. There was the question of whether what they did actually constituted a breach of fiduciary duty was not passed on below. And so to the extent that your question is driving at whether this is truly a breach of fiduciary duties, I think that would be more appropriately addressed by the trial court in the first instance. But, there are a number of actions that they took.
No, but what I'm saying is, and maybe I'm not clear, by virtue of their position, they were an advantage to you and to USF, and it was working, it was going pretty well. Pretty well. They're in global affairs and international student recruitment.
So let me just push back.
So when they make this decision, based on your rejection, and make these decisions that you're talking about, but I still can't see from the complaint what they did wrong for their own self-benefit or self-interest. There is no allegation they did anything to their own personal benefit.
The allegations are not that the directors personally benefited by this conduct. The allegation is that
That's in the course scope of their employment then.
So it isn't, and I just want to emphasize, so the fact that, these people may have served in positions related to international recruitment in no way means that they had to, or they would have reasonably even expected to do so by serving on the board of a joint venture that is 50% owned by the state and 50% owned by a private company. And I just want to point out how unusual this arrangement is. And in fact, the directors cite to a provision of the Florida Constitution which prohibits state agencies from jointly owning for-profit corporations. So sure, I would grant you that it is probably the kind of conduct that someone is hired to do if they are working in international recruitment and they work on something within the structure of USF relating to international recruitment. But that is not what this is. There are no allegations that suggest that the directors were hired to do this. And in fact, the pleadings allege for each of the four former directors that service on the joint venture was not one of the responsibilities that they were hired to perform.
Right. I guess what I'm having a hard time reconciling, and I think Judge Farfalla did below. Judge Farfalla.
Yeah, that's right.
No, I think I can see where there's this, on the one hand, your argument entails this notion that these people, for purposes of our community, this is not the kind of work for which they were suited. They weren't doing this. USF does not really benefit from this by hiring them to do this. And yet, fortuitously, coincidentally, all of their actions, as you allege, benefit USF? I mean,
Yeah,
you
let me-
see that there's,
I understand your question, Judge Lucas. and
Yeah.
What I want to say is, we're not saying that these directors were not well suited to perform these positions. We're not saying that they weren't qualified to do it. But in fact, in the case law, you see all the time in the scope of employment test, employees carrying out tasks for which they are perfectly well suited. Like, for example, you'll see a police officer driving his patrol car to work while monitoring the radio. He's obviously suited for that position, but the question is, what is the conduct that the officer is hired to perform? And on the pleadings here, there is nothing that establishes that the conduct that these individuals were hired to perform entailed service on the joint venture. In fact, the pleadings don't even tell you whether for certain of the individuals here, the joint venture even existed when these people were hired. So the point is not that these people were poorly qualified for service in the joint venture, that they didn't have the right skills for it. The question has to look at, what were they hired to do, and whether this is that kind of conduct.
You're into your.
Thank you, I'll reserve my time.
Keep going, you can.
I'll reserve my, however much is remaining.
Yes, sir, 4.5.
Thank you.
Thank you. Good morning.
Good morning. If it may please the court, my name is Hannah Sandridge, and I represent Ms. Condon, Ms. Holbrook, Mr. Trivinovich, and Mr. Wilcox. I can tell from the questions that the court is asking that you understand the arguments that the appellees have made today. And so I would like to focus on three very specific issues. First, this idea that the trial court did not expressly find that all three prongs were satisfied. It is very clear from the transcript that Judge Farfante did recognize all three prongs, and he just verbally discussed one of them because it was the subject of discussion during the course of the hearing. There is nothing in the law that requires the judge to expressly make any findings on the three specific issues that relate to scope of employment. There's another issue that I noticed in the reply brief that I would like to mention, and that is this idea that the USF employee directors are not acting within the scope of their employment because their job description doesn't require them to commit tortious conduct. Clearly, that is not the standard for sovereign immunity. The issue, of course, is whether their conduct is the kind or type of conduct that the employee is hired to perform.
this isn't on summary judgment, though. This is a motion to dismiss, and that issue, especially at the level that these individual employees are hired at, seems to me, intuitively at least, like the kind of issue you would want to get a factual record on.
So if we didn't have such a detailed complaint as Judge Sleet recognized, I might agree with you. But this is an unbelievable amount of detail about who they are, what they do, and the goal of this company and why it was formed on behalf of USF. And so, yes, Your Honor, in a typical complaint without all of this, but they went back a second time to try and get around it. They put all this information in there, and so it's available to us. We are not going beyond the four corners of the complaint. So let me give you an example. Ms. Condon, for example, she is, they put in the complaint what her job description is. She is the deputy CFO at USF, the deputy CFO. And they also allege what the purpose of this relationship was with USF, and that was to increase the revenue for USF through international students.
Inherent in a joint venture is the idea that all the participants in the joint venture are looking out for their self-interest. That's what the thing is.
Absolutely, and that is why they were there. And the agreements, again, attached to exhibits, and so we're not going outside the four corners of the complaint, shows that they had that power. And so what we have are allegations in this complaint that show specifically that Ms. Condon, who was in charge of the finances of USF, and we have an entity that was formed to increase the finances of USF, that certainly falls within, and I quote, kind or type. I don't know who else would be in charge of that. And so they have pled right into this specific allegation. And it's the facts that are contained in the second amended complaint that get us past the need for summary judgment, Your Honor.
Forgive me if this is a little bit of off topic or field, is there pending breach of contract litigation, or is that?
Yes, I'd like to add that.
Where that is, I just don't know.
So there is. So, and I think this is really important and proves our point. And it goes to whether, these folks did anything wrong to begin with, but there is an allegation in the complaint. It's paragraph 137 of the second amended complaint that says, here are all the damages. And it's incorporated into every single count. And one of those counts is a count against USF for breach of contract. And so, I want to say, Your Honors, there's no harm, no foul here, because they're already suing USF for this breach of contract claim that nobody,
Breach of contract is not ordinarily subject to sovereign immunity.
It's not.
Even against public entity.
it is not. There are certain terms that could be outside the contract that might be subject to sovereign immunity, but a standard breach of contract saying that you breached the terms of this
The
contract.
state puts its sovereignty aside and says, I'm gonna deal with you on the square and on the level.
And so let me bring this full circle, Your Honor, because of that question. So that's the whole point of the sovereign immunity statute that says that, employees who are acting in the course and scope of their employment, we're not going to hold them responsible. It's like the bus driver that I cited in my brief. The bus driver who's driving a bus on behalf of the state of Florida owes a duty to the motoring public and kills somebody at a crosswalk. As long as they're acting in the course and scope of their employment, we have the defendant, and that's going to be the state of Florida. They have the defendant here. It's USF. If there are any damages caused by this termination, they have alleged those damages through the exact same damages they're alleging against the USF employee directors. And so we believe that further shows the scope of employment test was satisfied here. If there are no further questions, I will be seated.
Thank you. 4.5 minutes.
Thank you, Your Honor. So just want to go back to Judge Lucas's initial question about summary judgment and why you might need a factual record on this kind of case. And, Ms. Sandridge pointed to Ms. Condon, for one example, of one of the directors, and why the pleadings established in her view that this falls within the scope of her conduct. But, if you look at the actual complaint, which is the only thing the court can look at right here, for Ms. Condon and for each of the 4 directors that we point to, there is an allegation in the complaint that serving as a board member to the joint venture was not one of the responsibilities that she was hired to perform. And, I think the fundamental flaw that is permeating the analysis with respect to Condon and all of the other directors is that because they, in fact, served on the board of the joint venture, it necessarily was the kind of conduct that they were hired to perform. But that doesn't mean that the court still must look at what conduct she was, in fact, hired to perform. And here we have allegations for her and for each of the other directors that she was not hired to perform this conduct. For Ms. Condon, just as an example, we have, in the complaint, I think she served in 6 different positions at USF over the course of her tenure. There's no analysis in the trial court's opinion, in Ms. Sandridge's brief, as to what conduct she was hired to perform in each of those 6 positions. This is a complicated analysis, and simply saying, oh, she had the qualifications to serve on the board of the joint venture, or that there was some overlap between what she was hired to do because she was hired to promote the academic interests of USF, and that was also what the joint venture was intended to do. That doesn't mean that that's the kind of conduct that she was hired to perform. Just to address one other point that came up, of course, yes, there is pending breach of contract claims against USF in this case. Of course, USF is vigorously defending those claims, and we are entitled to pursue alternative theories of relief. Here, a breach of contract claim. And so, of course, it is possible, we think the breach of contract claim will be successful. It may not. The fiduciary duty claims require different proof, different elements, and we're entitled to pursue those different claims.
Don't worry, our disposition will not be based on any other pending causes of action.
I agree.
I'm just curious.
Right, but it goes to the broader point about the point of sovereign immunity. And so the bus driver example that Ms. Sanders gave, yes, in that case, you might have either a claim against the bus driver or against the state, but in either case, the plaintiff would be covered. But that's not this case, because this is not a personal injury case. The argument here, we're not seeking to hold the university or the state liable for the breaches of fiduciary duty that are at issue in this appeal. The state has taken the position that it itself cannot be vicariously liable for economic torts. So the only possible remedy, the only possible way to pursue these fiduciary duty claims is against the directors. And so if the court holds that those claims are barred under sovereign immunity, then there is no remedy at all for those breaches. If there are no further questions, we ask the court to reverse.
All right, sir, thank you very much. Very well argued. I'll think about. You have a nice day. Good to see you. We have one more case. All right, so Ashley Morgan versus Brett Morgan.